We had a client in Tallahassee that recently, unfortunately, was injured severely from falling off of steps where there was some liquid that was allowed to remain on the steps. It was at a neighbor's house, but the neighbor was the tenant and not the landlord. So the question was, do I have a claim, number one? Number two, how do I proceed? Well, the first analysis is always difficult for premises liability. You have to decide whether there is a claim. Just because you fall off of steps doesn't necessarily mean you have a claim. So the liability analysis is there. But the question as to whether they can sue or make a claim against the, for instance, in this case, the landlord, the answer is yes. Again, but you have to establish whether there's liability. It's not just a case because you fall. Unfortunately for this particular client, he sustained damages that exceeded $400,000. So it was definitely worth getting a thorough analysis of the liability portion of the case before we could decide whether there was a case. Give us a call and we'll be glad to look at your premises liability claim.